The state budget taking shape as leaders agree on a framework for the state's spending plan. Hear from a legal expert on the impact it will have. Hello and welcome to Empire State Weekly. I'm John Gray.
And I'm Jamie DeLine. After almost a full month of negotiations, a state budget agreement has been reached.
Now, while the budget itself isn't over and done with, the agreement does lay out the path forward.
The governor spending this week touting the $254 billion budget agreement. It includes universal school meals, a middle-class tax cut, a $1,000 tax credit for families, and free college for those going into high-demand fields.
The next step here is to print and vote on the budget bills. As of this recording, they are working on that right now.
Another policy item included in the budget that caused debate and delay are the proposed changes to the state's discovery reform. Under the new measure, prosecutors are required to prove that they exercise due diligence in submitting all evidence before a trial can take place.
Now, opponents argue that the measure would end some protections that prevent wrongful convictions.
It's going to allow us to get to the merits of a case a lot faster. It's going to cut down on unnecessary litigation, which for us here upstate was a giant problem.
Joining us now to give additional insight on the changes to discovery law, Bob Babcock. He's a lawyer specializing in criminal law at Tully Rinckey. Bob, thanks for coming on today.
Thanks for having me, John.
I want to do something the media generally doesn't do, which is kind of a broad look back to put this in perspective. Before they changed the law, what was happening with discovery laws? It felt like the complaint was that if you're a criminal defense lawyer like yourself, prosecutors were kind of dumping things on you late or close to trial date, and it wasn't giving you time, a proper time to form a defense. Is that what was happening before they made the first change?
Yes, those were the arguments that were coming from members of the defense bar, that we were not given enough time to prepare the defense if information was given to us at the last minute. Some of those claims maybe not were not exactly legit, because some of the things that were withheld that the defense bar used to kind of get a dismissal or get an extension may not have been truly relevant. But yes, those were the arguments coming from the defense bar.
So then they try to reform it, and like everything that seems to happen with the state, this is my opinion, not yours, they always seem to overcorrect. They try to fix it, and they almost go too far. Then we start hearing from prosecutors saying, well, now we're dismissing cases. Criminals are going free because you've got this tight window on us, and we're understaffed and overwhelmed. And that was the argument to change it. Is that what you were hearing before we had this last legislative session, that we got to fix it and sort of correct back the other way?
That's exactly right, John. I think your analysis is 100% correct. They reacted in a way that put such a burden on the prosecution in terms of their timeframes that it really was unrealistic to expect district attorneys' offices across the state of New York to be able to provide everything that they needed to provide within those narrow timeframes. So it was an overreaction, and it was a very, very narrow window for the prosecutors.
Well, the governor certainly fought to keep it in there when the budget was going a month late. I don't know how privy you are to what changes they've made this time around. Are you happy or comfortable, do you think, with what's going to come down your way as a lawyer with these, I guess, a second correction, tipping it back the other way a little bit?
Well, I'm hopeful that the reasonableness standard will be brought back into these matters and these considerations. I do think that some of the recommendations that we're waiting to hear the final language on are reasonable. I think they do make sense. I think anytime you're tying a policy into the relevance of the evidence, the materiality of the evidence, and a reasonable time frame to make that available, I think those are good things. In terms of the statements, there's a provision that says that they're trying to reduce the time frame of statements to the grand jury from 48 hours down to 24 hours. That's a small change that I don't think is going to have an impact. But I do think that the changes that are proposed in terms of what the defense can challenge and how they can come to the prosecutor and say, well, wait a minute, we don't have this. We're not going to wait to the last minute anymore. The fun and games are over. We're going to be reasonable, but we're going to bring this to your attention and say, listen, without this information, we can't possibly prepare a defense because we don't have critical information. So my hope is that it's going to create a more open dialogue between defense attorneys and prosecutors about discovery.
You know, what's interesting with the law is everybody watches, you get a rainy Sunday and you watch 7 Law and Orders in a row, and everything happens within an hour. And one thing they don't do well in that show is show the discovery process. They kind of skip over that. And that can take weeks to gather things together and share. How important is discovery for you as a defense attorney? I imagine it's important because they do have to, an extent, show you their cards, right, of what they're gathering against your client.
Very much so. We do not have surprise discovery in the state of New York. The prosecution is required to provide the defense with all of the information that they plan to use against the defendant. And likewise, the defense is required to provide the prosecution with fair, reasonable notice of all of the issues that they plan to raise at trial. So there is a fairness standard. As to your question, how important is the discovery? It is truly the lifeblood of the case. The discovery is the evidence in the case. Discovery can include everything from the body cam footage of the investigating officers, the statements that were made by the defendant or any of the witnesses to those investigators. The discovery can involve the property that was seized, locations, dates, times, timelines. It's critical to both the prosecution and the defense that the discovery be exchanged fully, completely, and that there be discussions about what is truly relevant and what is necessary in order to go forward in a timely fashion.
And if police are investigating a crime against your client and they find something that's going to help your client, do they have to give that over to you, or is it only if they write it down in an official report? Do you ever worry about that, where things that would help you you never know about because it wasn't shared?
Yes, 100% on that as well, John. You have to have everything that's favorable to your client under the Brady law in this country. Brady set forth an obligation where the government, any prosecutor's office across the nation, not just in New York, must comply with Brady by providing any information that may be helpful to the defense. So that's a consideration that needs to be made on the law enforcement side, on the prosecution side. And also, as evidence and discovery is ongoing, a case is fluid and it's going to change with time. And evidence can come in that is harmful to the defense, and of course we need that. But evidence can come in that is helpful to the defendant, and that's equally important.
All right, Bob Babcock, a criminal attorney, Tully Rinke. Thanks for coming on. I wish we had more time. This is interesting, fun stuff to talk about, but hopefully we'll have you on after we get more details of exactly where this whole discovery change lands. Thanks for coming on.
Love to, John. Thank you.
All right. Helping students avoid distractions in the classroom. That's the goal of a statewide cell phone ban in public schools. That was also included in the budget. We'll hear from a school advocate on what it will take to implement this measure. Reminder, if you got a comment or story idea, just got to tell us about it. Email us at news@news10.com. We're also on X at WTEN. Welcome back to Empire State Weekly. We are keeping with the 2026 budget agreement. One major element included a statewide measure addressing cell phone use in schools.
Starting next year, cell phones will be banned in public schools bell to bell under the new agreement.
Governor Hochul has not yet provided full details on the plans for the cell phone ban in schools, but her office says schools will have some flexibility in how they want to implement it. Districts will decide how to store the students' devices during the day, and there will be exemptions for students who need access for their phones for medical reasons, learning disabilities, or perhaps a language barrier.
If approved, New York would join at least 8 other states that already have enacted measures restricting or banning cell phone use in schools.
All schools, all public schools will implement policies that free students from smartphones and other devices bell to bell.
However, this proposal has faced some opposition from parents who want to be able to reach their children in case of an emergency.
Joining us now to give additional insight and reaction to the statewide bell-to-bell cell phone ban is David Little. He's the executive director for the Rural School Association. Thank you so much for being on, David.
My pleasure, always. Thanks.
So let's talk about cell phones in schools. Is it really that big of a distraction for students?
Well, it is, much as you can see it being a distraction in everyday life. I mean, we've seen cell phones being a distraction to conversation, to family interaction, to work productivity. So it should be no surprise that students see adults modeling that behavior in the rest of their life, and they carry that into the classroom as well.
Now, what have teachers been doing to help solve this problem on their own?
Many schools have already implemented their own form of regulation of cell phones during the day. And for those districts, honestly, the statewide approach, the one-size-fits-all approach, really has caused them more problems because their own policies have been formed after talking to students and faculty and parents, having open forums, small group discussion with students, and they've come up with their own way of handling this issue. And many of them have found that that's been really successful. So now to change that based on no interaction of their school community, that's going to be a little problematic. It's led to some frustration. But barring that, there have been some preliminary effects that those school districts that already have a ban have seen, including some academic improvement, more productive study halls, better preparation for classes, and even perhaps some improved focus on academic tasks. But probably the biggest impact that we've seen, and hopefully would also be carried out under a statewide ban, would be that some students have shown enthusiasm for the change, that there's been a reduction in phone-related social issues within the classroom, and a more present and engaged student body. I do want to preface all of this by saying that we haven't seen the language yet. You know, we've heard it only said that it's a bell-to-bell ban, and we have to assume that, much like most policies that are imposed on public education, that the legislature and the governor will leave it to either the state education department to make regulations on how that's going to be carried out, or leave it to the state education department to authorize school districts themselves to authorize that. And you know, as always, we find that when the local school community is engaged in shared decision making, those are the policies that usually work out the best.
Yeah, other school organizations that I've spoken to say they wish that there was a little bit more flexibility. Have you heard from parents at all about how they feel about this ban?
Yeah, and you know, there are comments across the board. There's obviously the initial concern that most people know about, that parents want to be able to communicate with their child in an emergency. That will have to be covered in some way. Those kind of concerns hopefully will be covered in some way. Both sides of that issue, you know, if there is a school emergency, you want students to be focused on the directions they're being given by those on site and not distracted by trying to communicate with a parent and perhaps getting different instructions from the parent. So that's kind of a conundrum. But beyond that, you know, there is this issue of what are parents going to do after the school day? There's some concern by schools about our really treating this like any other addiction, in that whether it's smoking or any other kind of behavior that's prohibited at school, you encourage people that the moment that bell rings, that they're instantly going to the thing that's been forbidden. And so if we aren't modeling good behavior in our homes and in the workplaces, then giving the kids their phone, you know, as soon as the bell rings, may in fact lead them to being more addicted to the screen as soon as they're allowed to be back on them again during the day.
And how do you think teachers are going to take care of these phones? Are they going to, are some school districts going to have pouches, or are they going to have shoe racks that they can put the phones in? What are you hearing from the school districts that you represent?
Well, what I'm hearing is what's already been done. I don't know, and there's no way to predict how we'll deal with a bell-to-bell ban, as the governor puts it. There are these things called yonder pouches that are kept on the student, that the student keeps their phone but has the pouch. There's the approach that students will need to lock the phone in their lockers during the day. If there's no transition from classroom to classroom or study hall or lunch to classroom, then the teachers shouldn't be involved. And I know that was NYSUT, the teachers union's concern in all of this, is that they didn't want to make every classroom, the first thing that has to be done in every classroom every day is trying to make sure that everybody has their phones secured, because students may be in any number of different scheduling patterns where every student may be coming from either another classroom or a period where they would have been able to have their phone. And so teachers should be out of this. Hopefully administrators will be out of this. Those that already have some form of regulation of phones during the school day have largely found compliance and haven't found it to be overly burdensome in terms of administrative time or focus.
And as you said, we're still waiting to see the bill language on this issue. We have to leave it right here, but thank you so much for coming on. Always great to have you.
It's great to be with you. Good luck on it.
Thank you so much. After years of debate, New York lawmakers moving ahead with the Medical Aid in Dying Act. When we return, hear from supporters and opponents of this issue, what they say this controversial bill means for end-of-life care. If you have a comment or story idea, let us know. You can email us at news@news10.com. You can also reach out on X at WTEN.
Welcome back. The New York State Assembly has passed the controversial Medical Aid in Dying Act.
The bill would allow terminally ill adults to end their life by taking prescribed medication. I spoke with both supporters and opponents of the legislation at the Capitol. Take a look. 10 years after the bill was first introduced, the New York State Assembly voted to pass the Medical Aid in Dying Act.
Initially, it was, I don't want to say a strange concept, but it wasn't a concept that was embraced by a lot of the members and the community yet. And then slowly, the advocacy community really stepped up their game, came here, and worked very hard to convince a lot of members to become sponsors.
The bill would allow terminally ill adults with 6 months or less to live to request and self-administer medication to die. Before the prescription is given, doctors would have to sign off and conduct a mental health evaluation. 10 other states and Washington, D.C. have similar legislation. Advocates say this will allow people to have more dignity and to pass away peacefully. However, the bill is controversial and has been strongly criticized by New York Catholic bishops. It is also opposed by the Center for Disability Rights.
Other proponents of the measure would have you believe that this is about controlling pain and that this is used to end suffering. What we really see is people opt for this procedure because of acquired disabilities from their illness.
Max Rodriguez, manager of government affairs for the Center of Disability Rights, says there's also a concern that the legislation could be expanded in the future to include other types of conditions. Instead, the center would like to see more resources allocated for end-of-life care. While Medical Aid in Dying passed in the Assembly, it isn't law just yet. The bill is currently in committee and hasn't been taken up by the state Senate. Political fallout in New York City following the decision this week to raise the rent on 2.5 million New Yorkers. The increase coming from the Rent Guidelines Board, which controls rent increases across 1 million stabilized and controlled units. The board, under current mayor Eric Adams, has allowed several increases. A number of the candidates running for mayor are weighing in on whether or not there should be a rent freeze across the city's vast supply of rent-stabilized housing.
Landlord revenues are up 12%, but these tenants who are living in those units are on the brink of having to leave New York City because they simply can't keep up with these rents.
Mayor Eric Adams made the case that no rent increase is unrealistic. He suggests blocking rent increases would crush small rent stabilized landlords.
Palestinian activist Mohsen Madawi has been released after a judge ordered he be freed from federal immigration custody. A Madawi led protests against the war in Gaza while a student at Columbia University. He was arrested in April during an interview to become a naturalized U.S. citizen. Madawi has been a permanent resident of the States for 10 years now. His attorneys say the judge is allowing Madawi to leave Vermont and attend graduation next month. The attorneys also add, though, the government could appeal his release. Stick around. Back with a look at the week ahead in just a bit.
If you have a comment or story idea, let us know. You can email us at news@news10.com. You can also reach out on X at WTEN.
Finally, on Empire State Weekly, returning to the budget. As we said at the top of the show, a state budget agreement has been reached, but that does not mean the budget is actually done.
Lawmakers will look to print and then vote on the budget bills this week, which is a process all by itself.
We'll be sure to keep an eye on any developments or maybe late-turning developments and bring you the latest analysis on that. For now, from all of us here at Empire State Weekly, I'm John Gray.
And I'm Jamie DeLine. We'll see you here next week.
Don't you forget, you can watch this show all over New York State. Here's the full schedule of Empire State Weekly on 10 TV stations across the great state of New York.